today for the special lecture on the topic Alternative Disputes Resolution Techniques, Challenges and Prospects by Advocate Sumit Teterwal. But before we proceed with the lecture, I would like to throw some light on the colorful journey of our guest of honor today to become an advocate on record for the Honorable Supreme Court. He started his legal journey by graduating in law from Symbiosis Law School in 2007 and thereafter practicing in the Rajasthan High Court. In 2016, he qualified the prestigious Advocates on Record examination and moved to the Honorable Supreme Court. His endeavor for 11 years of practice showcases his experience of practice in the Honorable Supreme Court, the High Court of Rajasthan, the High Court of Delhi, and several specialized forums such as NCLT, NCLAT, NCDRC, NGT, etc., along with numerous arbitral tribunals presided by retired Supreme Court and High Court judges. He has also been associated with many senior advocates. Mr. Siddharth Luthra, Ms. Pinky Anand, Ms. Sham Diwan are few of the many such names. He has a profound knowledge on constitutional matters, state-central relationship, election laws, public service commission matters, and a myriad of other matters with a special knowledge on arbitration and conciliation matter, and has been associated with the landmark cases of Joseph Sloan versus Union of India, Asian resurfacing of road agency versus CBI, Shakti Varini versus Union of India, and many more. It's an absolute honor to have you today with us. Now, I invite you to please begin with your address.
Good morning, everyone. Thank you all for a very relevant topic that the university has today chosen. It's pretty pertinent in the present scenario, given the COVID situation, how the businesses are being affected and the contractual relations are under a lot of strain. And I do thank Ms. Mansi, as I understand, for a very generous introduction. Now, I have been associated with the arbitration practice for quite some time. And I'll take you through, firstly, the philosophy of arbitration as such. Now, India as a society has always had amicable dispute resolution at its core. The father of the nation, Mahatma Gandhi, always believed that whatever differences we have, religious, political, or otherwise, they can all be settled through mediation, through talking, through arbitration. So arbitration as such was never an adversarial dispute resolution system. It was where two parties came together. They submitted their dispute to an expert, and through discussions, we could just come to an amicable solution, which was, of course, binding on both of them, on the parties to the dispute, because, well, they'd agreed to a particular person to decide their dispute. They've given that power to him. They've vested that power in him. And because of that agreement, this is the basis. Because of that agreement, the award as such, as we can refer to in the language of the Arbitration Act, whatever decision was taken by that expert was binding because I agree to it. Now, historically, we've always had Panchayat Systems, where the group of elders was something that the society would nominate. The society would nominate in a particular village setup, let's say, to have jurisdiction on all disputes arising therefrom. So I'm not going to go to a formal court setup. What I'm going to do is that these experts or these elders that we have in our own village are going to decide whatever disputes we might have with each other as neighbors or within the economy of the village, which was self-sufficient during those times. So Panchayat as a system was an accepted dispute resolution mechanism in the older days. Now, with formal setup of the state in India, which began with, of course, the advent of the colonization, formal courts were brought in where, particular codes, legislations, enactments, which were codified, so to say, the codified laws came in to govern our social and contractual life. So that is how we accepted the court system But what remained essential and always has been, and it was eventually realized also for commercial spaces, amicable dispute resolution was always important. And what was important was that these disputes are resolved in a particular time frame. They should be expeditious. It cannot be that if I have a money claim or somebody arising out of a contract and he refuses to pay, so he's in breach, and then I go to a court which just gives me that money claim 12 years later. So my business is suffering. It might be a possibility that because of that claim altogether being decided after a decade, I might have closed shop. So this is where arbitration was always, or rather, this is the reason why arbitration was always the preferred mechanism for people who are businessmen, who have financial interests, who have commerce at the center of everything. Historically, let's say India, as we understand, is a huge country. And participation in the world economy, if we even go back so far as the Silk Route days, it has always been immense. But talking about the present days, we are contributing to the international commercial spaces, and we are a preferred investment destination. I mean, since the opening of the economy in 1991 with the neoliberal reforms that the Manmohan Singh as finance minister had brought in, and the economy opened up. So we were inviting, rather inspiring investment by foreign players. But what a foreign player needs, or any commercial entity would need, is a very robust contract enforcement regime. If let's suppose an MNC in the 1990s was to invest in India and there was a claim or there was a dispute which involved some amount of money, let's suppose it's going to be a huge amount anyway, if there's a big company. But anyways, so whatever the corpus of the amount might have been, but had that company been put through the rigors of the Indian judicial court systems, the normal civil courts, then by the time the claim would have matured, or they would have actually been declared the beneficiary of that claim, it would have been ages, or rather decades altogether. So what a investor needs is a very robust contract enforcement regime. If I am in breach, then I should be put to terms immediately. And that is why the older acts, which we always had, like the 1940 Act, Arbitration Act, and even the 1937 Act, and the 1961 Foreign Awards Enforcement Act, all these did not really have that strength in them. Neither were the courts, conditioned along those lines. Their behavior was different. They always wanted to go through the procedure, the CRPC procedures, or the normal court procedure where there's, hearing after hearing, and eventually when we come, then there's appeal after appeal, and every appeal can be, every order of the court can be appealed against. So those several layers of appeals and everything made it very difficult for anyone to realize his true money claim against somebody. And eventually it was decided, and it was felt in 1996 when we came out with a better act, which was modeled on the UNCITRAL model, as we call it. Minimum court interference was something which was aspired for. The courts could only intervene in the most extraordinary circumstances. Like most of you would appreciate that in the 1940 Act, even if there was an award passed by the arbitrator, then for that award to be enforced, I had to go to the court, first get that award converted into an order of the court, and thereafter that became enforceable. While under the 1996 Act, the award was enforceable as such. I don't have to go to the court to get it converted into an order of the court. What I need to do is file a Section 36 application. It is enforceable as such. The objections were minimized, and this is how we proceeded therefrom. So the endeavor has been since 1996, and which was reflected in the 2015 amendment, which was also reflected in the 2019 amendment, is that there should be a very minimum interference by the courts. The court should always be in the favor of the award. If there is an objection to the award, the presumption is that the award is right. And the grounds are extraordinary if we see. Section 34 applications have specifically, if you go to section 34, which is in the present shape today, the grounds for challenges have been pinpointed. There are specific grounds. There's nothing extraneous that the court can bring in and say, all right, fine, to a suit, in a civil suit, if there is an order or a determination, the decree can be challenged on several grounds and an appeal will go into all facts again. A section 34 objection today is not an appeal. It is not in the nature of an appeal. So this is how the courts, the legislation and everything is proceeding to have a very, let's call it arbitration friendly approach. If I go along with a contesting party and submit my dispute to an arbitrator, whether institutional or private, then the endeavor by the courts is that because you have submitted to the jurisdiction of a private individual to have your dispute redressed, whatever that private individual has decided today is binding on you. There's another aspect of this thing. Why is arbitration important? Well, if you would see that since quite some time, in the last 3 decades or about 25 years of the working of the 1996 Act, you would see that the infrastructure sector in India has been at the forefront of driving the GDP, the economic development of the country. Even world over, if you see the Chinese initiative of one road, one belt along the Silk Route, where the Chinese government is developing several ports and infrastructure projects in the Central Asian and other countries. Arbitration is the only method of dispute resolution. So infrastructure investment is increasing. If you take infrastructure related disputes to a court, then in most cases, you have a generalistic court. It's not a specialized court. It's not like the judge is, with due respect to the judges, it's not like they are trained for the infrastructure dispute resolution process as such. So that behavior which is involved, if you have an expert who has been associated with the construction industry, an expert maybe who's been associated with the petroleum excavation industry or other mining related activities, industries, then such an expert is in a better position to address your disputes. Courts are generalists in nature. They would always are guided by the procedural codes, whereas an expert from the same industry will understand the exigencies of the industry. He is interested in the continuation of the project. He's not interested in snapping off the project or the contract altogether and then decide the dispute. So several times the project is ongoing and yet the disputes are being decided amicably on the sidelines when the parties agree to whatever the arbitrator decides. So this is how, for a scholar and for an arbitration practitioner, this field is immensely important, has gained huge impetus over the last 20-30 years. So far so that countries like Singapore have become international arbitration hubs because of the surety, that the court intervention process will be a minimum and the contracts would be enforced with certainty at the earliest. So if a country is investing, like let's suppose we had I'm sorry to use the wrong word here. Let's not suppose we had a case here where the Australian coal company was investing in India. It's called the White Industries Award. The award solely went against the Indian government because of the huge delay in disposing of the Section 34 and Section 36 applications by the various high courts and eventually by the Supreme Court. The tribunal was of the view that this judicial delay in disposing of these applications and in the enforcement of the award as such was a breach of the treaty obligations, and therefore the government was constrained to pay a huge amount as for damages to white industries without even the coal production beginning. So in contracts which are relating to the government, like we have huge agencies in the government like the NHAI, we have the Steel Authority of India Limited, who have huge infrastructure projects pending. The delay created by these PSUs becomes something which is not really appreciated in the private commercial spaces. Like a private player wants his project to be expeditiously completed so that he can use his resources elsewhere. While that might not be really the driving force behind a PSU in its method of working. So I have here tried to explain and highlight why arbitration today as a field of practice is immensely important. It is because it has now today become a parallel structure of dispute resolution, which is preferred to the traditional court setup. Now, with the increase that we have seen in the international investment that is coming India's way, it is important that we strengthen this contract enforcement regime. We have refined rather and reformed our corporate structures. We have brought in the Insolvency and Bankruptcy Code. We have the Commercial Codes Act for expeditious disposal of commercial matters. We now have very well refined and rather matured legislations in the nature of the NCLT and NCLAT for the company's dispute resolution systems. We have the debt recovery tribunals, which have been refined to international levels. You can't just today keep a bank's loan and feel merry about it, because the bank is going to come after you and take your securities altogether. So with this, we had a committee in 2017 which had scrapped about 1,000 almost archaic laws, which were just existing on the statute book. And on certain occasions, they were taken benefit of by unscrupulous litigants also. So the commercial space is being, streamlined towards a better economic and a stronger contract enforcement to bring in more investment. And that is why arbitration today has reached the epitome so far as dispute resolution systems are concerned. We would see that even the Prime Minister in recent, he was addressing the National Initiative towards Strengthening Arbitration and Enforcement in India seminar, where he has asserted that the government is going to involve itself into far-reaching legal reforms. Now he says we are going to create vibrant arbitration mechanism, as investors need to be assured that the rules of the game will not be changed. Surety of the laws, what is governing me should remain constant for as long as I am involved. So we are not going to change arbitrarily the rules that are governing the commercial disputes. This is what the Prime Minister has stated. And in his words, we'll say, well, as he said, business, I'm quoting, businesses seek assurance of the prevalence of rule of law in the Indian market. They need to be assured that the rules of the games will not change overnight in an arbitrary fashion, and that the commercial disputes will be resolved efficiently. A robust legal framework backed by a vibrant arbitration culture is essential. Having said this, I'll now take you to how arbitration has actually grown over a period of time in India. It has had
Excuse me, sir, you have gone on mute.
Am I audible now? Yeah. So I'll resume back. I've already stated, I suppose, the initial arbitration acts and legislations that were governing the space before independence, which was 1940 Indian Arbitration Act and the 1937 Act. of which was called the Arbitration Control and Convention Act. We also had the 1961 Foreign Awards Recognition and Enforcement Act. Now, the 1940s Act was a general law governing arbitration in India along the lines of the English Arbitration Act of 1934. Thereafter, as and when we recognized, we came up with, the need was recognized to reform. We came up with the 1996 Act, which was modeled on the UNCITRAL, as they call it, the UN model law. Now, after the UN model law, the 1996 Act now covers both domestic and international commercial dispute resolution. And it provides for an effective and expeditious framework. It has two significant parts. Part one, now this is solely, my approach today is solely because I have been given to understand that I am mostly addressing students who either have taken up arbitration or they're about to in the coming session or so. So I'm going to keep it fairly general and not venture into the technicalities as required. Part one of the 1996 Act includes and applies to the domestic arbitration. Part two is for enforcement of foreign awards. Now, 1996 Act was enacted, as I've already stated, for the twin goals of inexpensive and quick resolution, but that was not how it fared out, because the courts were traditional in their nature, their behavior, or their understanding of the development of the jurisprudence in the courts was such that delay still occurred. Despite the fact that we had a very brilliant act modeled on the international practices, but the way we dealt with our cases, delay still occurred. Now, in order to do away with this, in 2015, we came out with the amendment whereby we had put a time limit on dispute resolution. Any arbitration now has to be concluded within 1 year from initiation of the arbitration, as it is initiated in Section 21. The process starts as soon as I serve a notice of arbitration, I invoke arbitration, and therefore the constitution of the arbitral tribunal, it shouldn't take more than 1 year. It is extendable by 6 months on an application under Section 29A. Now, having said that, what is essentially arbitrable? Can you take every dispute to arbitration? You must be cognizant of this case, which was the Augusta Westland VVIP helicopters purchase case. Now, Augusta Westland, although it was also there was also a criminal aspect to it. I mean, there were CBI inquiries against certain people who were involved on the allegation of receiving kickbacks and whatnot. Now, Augusta Westland had invoked arbitration before the London Center of International Arbitration. It was being conducted in Delhi, with a seat in Delhi. The objection which was raised on behalf of the Republic of India, as this was the nomenclature how India was a party. It was not like Union of India. It was made a party in the nomenclature of Republic of India through Ministry of Defense. Now, I was associated with the case, and we had taken an objection before the tribunal stating that because this case, the contract involves criminal elements also, the contract was secured by fraud, and there was bribery involved. There were allegations of misdoings, commercial misdoings altogether. So this is a dispute which should not be put to arbitration, and this is what we told the arbitral tribunal. The tribunal, well, kept the application pending and said that we'll decide this issue eventually when we decide the main matter. Well, dissatisfied, the government went to the Delhi High Court, approached the Delhi High Court, and the Delhi High Court, although the question of law could not be decided as we had raised it there, the company became cognizant of the fact of how a contract which was secured by fraud and a dispute which also has criminal aspects to it, would not be able to reach fruition. And they withdrew from the arbitral proceedings under that pressure. So although our argument was not really answered, but maybe it was the force of the argument that led the company to withdraw from the proceedings. Now, so that proceeding came to an end because they gave an undertaking before the High Court of Delhi that they are going to withdraw from the proceedings under the pressure of the argument that a contract secured by fraud or criminal misdoings is not arbitrable. So essentially, arbitrability of a dispute is the first and foremost thing. I mean, of course, it is after the basic initials that there should be an arbitration agreement, which is the bare necessary requirement. Once you have proved that there is a valid arbitration agreement existing, then the arbitrability of the dispute is within the arbitral tribunal's competence to decide, which can, of course, be challenged by Section 34 eventually. But the present law, as it provides, it gives so much. I'm sorry. Seems like there's some disturbance somewhere. Anyway, so I'll resume. So the competence to decide about its own jurisdiction has been given to the arbitral tribunal only. So this is how far the 2015 Act, the UNCITRAL model, and the 1996 Act have paved the way towards giving the arbitral tribunal competence, or rather the sole discretion to decide about its own jurisdiction. The underlying object of this principle is that there should not be a delay on every intermediate stage. Earlier, there used to be a challenge to even the appointment of an arbitrator. Then there were interim orders being secured by parties, which delayed the process on and beyond. Today, the principle governing is competence, as they call it. The principle is called competence principle. This principle underlines the fact that the arbitral tribunal, because you have chosen the arbitral tribunal and you have submitted your disputes to the arbitral tribunal, it shall be the sole authority to decide on its own competence, whether it has jurisdiction or not. You can raise eventually a plea that whatever dispute is being submitted to you today is beyond your competence, but that has to be decided by the tribunal itself. And the only challenge that you can make to this decision of the tribunal will be when you challenge the award or take objections against the award under a Section 34 application before the High Court or the concerned court, depending upon the amount involved. The second principle is that the rules of how the arbitration is to proceed can be determined by the parties themselves. So this is the party autonomy. Under the earlier Act, it was not so clear under the 1940s Act, and the jurisprudence didn't grow that far. So what was happening essentially was that the courts being, rudiment, they were guided by their own experience in dispute resolution. So if it was a sessions judge, knowing how he has proceeded all his life in dealing with disputes of civil or commercial nature, he would invariably utilize the procedures provided under the CPC. So he was trained that way. Eventually now the behavioral shift, or as we call it, the paradigm shift, is that CPC procedures will not be applicable. I'm not bound by each and everything that is stated in Order 21 and whatever concerned rules there are. What is required is that I may follow the principles. The broad principles may apply, not these specific provisions. With this understanding, what happens is that a dispute resolution proceeds on a very fast track mode. The parties at the very beginning can say that we are not going to adduce any oral evidence. We are going to rely is only documentary evidence. and will specify what document was in the possession of what party and who's producing it. Authenticity, if disputed, can be seen by the tribunal. And this is how today the mechanism of dispute resolution through arbitration has become so fast-tracked that even the legislature had the confidence of putting a time limit of 1 year. Had this behavioral change not been effected in the judicial higher-ups, we would not have been, the legislature would not have been able to have this confidence of enacting a law which says 1 year. Because of course the legislature does not want to enact something which is unachievable, right? Had it been the good old days of 1996, this cap of 1 year would have been followed more in breach than in observance, right? So given this commercial understanding that the judges are now coming to, rather than the traditional way we were dealing with disputes which are of commercial nature, the procedural the procedural requirements of CPC have been ignored. Even so far as the Evidence Act applicability, the basic principles are being followed, but not every section, not every nitty-gritty is being brought in. That's the first. Thereafter, now I'm not going to go into the sections as such, the procedure provided, because I suppose this is too short a time for that. I'll come to the objections. Once an arbitral award is passed by an arbitral tribunal, it may be an institutional tribunal. Yes, of course, I'll come to the institutional tribunal part a bit later. Or it can be an individual tribunal, a one-man tribunal or a three-member tribunal constituted by the parties themselves with agreement or by intervention of the court under Section 11. Once the tribunal comes out with an award, minor disturbances, I suppose, will keep occurring. So after an award is passed, it is binding on the parties as such, without being brought to the court's notice, without this award being converted into is the moderator who could mute Mr. Mohammed Adil, I suppose? Right. So once an award is passed, prior to its enforcement under 36, there is a provision of taking objections. It has a very interesting development recently. Earlier, what was the understanding was that as soon as Section 34 application, I hope everybody understands Section 34. If, give me thumbs up if you do. All right. So a Section 34 application is essentially objections that you take against the award on several grounds, which are mentioned in the section itself. And over a period of time, there have been very specific grounds that you can take an objection to. Once a 34 was filed under the erstwhile 1996 Act, it was a presumption that the award is stayed. And I myself have worked under that assumption for a very long time. So we used to presume that as soon as a Section 37 application is put in the court, the enforcement cannot be filed because there is an implied stay of the award itself. As recent as the judgment was Bcci versus Kochi, Justice Nariman's order, he clarified for the first time while they were interpreting the effect of 2015 Amendment Act as to whether there is an automatic stay or not. So this we used to call the automatic stay. As soon as you put a Section 34, the other party is constrained from filing a Section 36 application for execution of the award. Bcci versus Kochi was not really deciding the question of whether there is an automatic stay or not. What it was deciding was that what or how the applicability of the 2015 Act will come into play. Whether the provisions of the new Act would apply to arbitration proceeding which is commenced before the Act. The reason for this was that in 2015 amendment, the section 36 was amended and a clause was inserted which said that stay would only be granted on a specific application made on the same conditions as would require a money decree to be stayed. So 2015 became the cutoff line wherein a specific application was to be made always. If I am going to object under section 34 and I seek a stay, then I have to seek a stay specifically on an application, unlike the earlier scenario where a simple filing of a 34 would stay. The award and its execution could not be filed until the 34 was pending or it was disposed of, howsoever it was. The outcome was important. So until my 34 is decided, since up till the year 2015, with the amendment, I could not seek enforcement. I was constrained. My hands were tied. The other party was not to put any money in the court, as was a practice for money decree to be stayed. I suppose all of you know that under CPC, if you need a stay of a money decree specifically, you have to follow the conditions the court imposes on you. The conditions usually are that you deposit certain percentage of the decretal amount. So this condition was not applicable in the case of section 34 prior to 2015, because it merely stated that section 36 can only be filed. It was the understanding once a 34 has been disposed of. This was clarified by the amendment because the amendment wanted a further friendly approach towards commercial contracts. And the amendment provided that stay can only be granted on a specific application. This application for stay has to be made. Now, the dispute that arose before the Supreme Court, finally, it arose before the courts and reached the Supreme Court and was finally decided was whether 2015 provisions would apply to arbitration proceedings which were pending before the act came into force. Now, BCCI in Kochi, which was if you remember, there was an IPL team by, I don't really recall the name, but it was Kochi. It was floated and there was a dispute. So an arbitration proceeding commenced and thereafter section 34s and whatnot. The decision was important because in this case, the court created a distinction. It read a certain portion of the Amendment Act in such a manner so as to distinguish court proceedings as being different from arbitral proceedings. So an arbitral proceeding, the court said, would only be proceedings before the tribunal. And if the proceedings before the court are pending on that particular cutoff date, then the new act would be applicable. So let's say if my award came before the cutoff date and I initiated my court proceedings after the cutoff date, then the new act would be applicable. The contention was that because the court proceedings as such are a continuation of the arbitral proceedings, so the old act should apply, meaning that whatever arbitral proceeding has started with the invoking of the arbitration prior to 2015 cutoff date, which was, I suppose, 23rd of October, the old act would apply for all times to come until such time that the court disposes of the matter for good. This was disputed, and Justice Nariman very rightly, keeping in mind the object and reasons of the Amendment Act, said that it is in the fitness of things and it is according to the philosophy. So what we do is we'll apply the new Act of 2015 and its provisions to court proceedings that started after that particular date, which is 23rd of October. So this distinction was created. Now, the government was aggrieved because there were huge awards. There was one company called the Hindustan Construction Company. It was a case I was associated with as a government counsel for the Union of India. So while appearing, what we were trying to defend was a subsequent amendment which tried to undo the effect of the 2015 Act. The effect of the BCCI versus Kochi judgment. Interestingly, the court was apprised of the fact that the government is about to introduce an amendment to undo what you're trying to say right now. And the court had cautioned the government not to go further with such an amendment. It was an interesting happening where something was brought to the notice of the court, which was about to happen, and the court said, don't go like this. But yet the government introduced the 2019 Act. And by this amendment, we tried to undo what was said in BCCI versus Kochi. And the philosophy or the underlying object was that because we have huge awards against us, there are companies who have awards to be enforced amounting into thousands of crores and against the NHAI, against other PSUs, the IL and FS companies and all that. So this is going to create a huge burden. So to undo this financial burden that was to be put on the government because of the judgment in BCCI versus Kochi, which was of course of far-reaching implications, the 2019 Act introduced saying that court proceedings in relation to arbitral proceedings which were initiated before 2015 will be governed by the same Act. So there will be an automatic stay, so to say. This amendment was struck down. We tried to defend it with whatever we had, whatever capacity we could. But eventually the government lost, and the section 89, which was introduced by 2019 Act, was struck down. So now the clarity which has come is there was never an automatic stay regime. The section 34, section 36 of the old Act, if you read together, Justice Nariman was of the opinion that this is a faulty understanding. There cannot be an automatic stay on anything without asking. The court cannot grant something which has not been asked for. So it comes as a welcome development to the commercial players or the private investors that there has to be a stay on an application subject to certain conditions. Now, what are the conditions the courts are imposing these days? Well, it is also the courts, and somewhere there has been some commercial wisdom by the government also. So in 2016, after the 2015 amendment, the Niti Aayog, the old planning commission has now been called the Niti Aayog, it came up with a circular whereby 75% of the decretal amount, as in the award amount, would be deposited or released as soon as you file a section 34 objection to the award. So if there is a 100 crore award and I want to challenge it as a government, it is only applicable to the PSUs. It is not a general thing. So it was a direction given by the government to the PSUs that if you are going to challenge a section 34, an award under a section 34 application, what is imperatively required of you to do is that you will offer to give the other party 75% of the award value. So it is a self-imposed restriction of sorts. So that is what now the government is doing. However, it is not binding on the courts seriously because it is only a guideline how the government is going to behave within itself. The courts are going so far as imposing conditions such as giving bank securities. In case there are two private players, if the government is not involved, they'll ask the other party to secure that amount of award, either through bank guarantees or depositing it in court or handing over the money to the beneficiary, to the claimant, successful claimant, so to say, so that the business or the project does not stop. Let us suppose a construction company, a private construction company like HCC, in Hindustan Construction, which claimed to have about 6,000 crore rupees as due in awards with the government. If this company is denied access to this 6,000 crore rupees, the IBC or the Insolvency Bankruptcy Code would straightforward start applying because, well, jinko unse paisa lena hai, they'll approach. And with a demand of 1 lakh rupees, I would say, if this company is not paying me, let's take it to the IBC proceedings, wrap this company up. So I wrap up a company because the company could not secure its dues from the government. So for no fault of its, huge business houses come crumbling down because the arbitration proceedings could not secure their arbitration awards. So this is one welcome development that has happened over the period of time. So now we have Section 36 enforcement as a more robust mechanism. So escaping or fraudulent dealers who would just go to the arbitration proceedings for the sake of it, thinking they'll delay it in the court, their modus operandi has been destroyed. It has been put to shambles by the recent amendments. The government is very alive to the fact that keeping intact commercial relationship is far more important for the economy, for the commercial spaces to thrive. Because if we want to continue with the 7% growth rate that we have been able to maintain over the last 2 decades, we need to be very sure that our courts or the judicial system does not come in the way. As you would have seen how much criticism the courts had received from several players, including Mr. Harish Salve, the senior counsel, when the judgment in the Vodafone case or the retrospective taxation case came out. And he was pretty much very eloquent when he said that Supreme Court, by its one stroke of pen, has caused immense damage to the economy of the nation. So that is how the commercial spaces are developing. And that is why I would implore all of you to focus much more on ADR as an area of study presently, and eventually whenever you pass out, as an area of practice. There are several firms which particularly and specifically work only in the field of ADR. They don't practice adversarial litigation. They don't do court litigation. They do only ADR work. There are several international firms doing ADR work. And India has now also, the new amendment has also established an international arbitration center. And we are promoting India as an international arbitration hub. It was the endeavor of the late Mr. Arun Jaitley, and it is the endeavor of the Prime Minister. It is certainly the endeavor of the Niti Aayog members, who are very much focused on how arbitration can be given an impetus. Because, well, you'll have to understand that arbitration is not only dispute resolution simply. Arbitration is an industry today. There are arbitral institutions who are commanding huge fees, which also has been capped by the recent Arbitral Amendment Act. You can only claim a particular fees and you can't claim exorbitant fees. There are sometimes even obnoxious results, like, the arbitrators' fees was way beyond what the parties could secure in the award. 1 crore ka award tha aur 1.25 crore rupees fees mein chale gaye. So that has also been capped now. So there is a particular slab. You cannot ask for fees beyond that. There have been occasions where I have myself personally defended PSUs on this ground that the arbitrator has fixed his own fees beyond and above what has been capped by the Act itself. So it is becoming more streamlined, and I would implore all of you to put a lot of thought into choosing this as an area of study and practice. Now, coming back to certain other aspects as to how the Arbitration Act has helped the recent amendments and the understanding, the change in the behavior or jurisprudence has helped us into becoming arbitration friendly, as to developing into arbitration hubs. India is endeavoring. There is International Arbitration Center in Mumbai. There is one in Delhi. They are coming up with a National Arbitration Center also. There are going to be rules and training, so to say, so as we have a universal standard of imparting training to upcoming arbitrators or arbitration practitioners. Now, there used to be as you're aware always, in the Indian judicial setup, interim orders is something that every litigant is afraid of. I go to a court, or let's say every litigant is fond of. Right. So I, as a party defending, might be scared of it, but as a party claiming, you might be very fond of it. You want it so much. Why are interim orders so appreciated? Well, because the understanding is once you get it, you can just go to a slumber and sleep it off. Right. By the time the judge wakes up or somebody else wakes up, it will be decades. And I don't know, maybe my grandson is going to defend the case sometimes. So there have been instances of that sort. And that is why even in arbitration, there were occasions where people just, the arbitration proceeding before the tribunal are pending, and litigant would just approach the court and seek an interim order. Once that interim order is secured, he has some sort of a benefit coming his way. Thereafter, he'll start stalling the proceedings. And then they go on, the time runs, the cost overruns, and just sometimes in adversarial litigation, sometimes the strategy is to tire the other party out. I'll exhaust you to such an extent that you'll just give up and you'll withdraw from either the case or the proceedings. Now that approach, the committee which was sitting, which is Justice B.N. Sri Krishna committee, if I am right, they were very much aware that these interim order approach of the courts has to be curtailed. So what they did was they introduced Section 17 and Section 19 in the Arbitration Act, and they amended them eventually, wherein the tribunal now has the same power to grant an interim benefit, if at all. Now, the tribunal's life is limited to 1 year. So in any case, the interim order cannot go beyond 1 year or the extendable life of 6 more months, thereby limiting the operation of such obnoxious, sometimes such interim orders, from creating commercial hardships to the genuine litigant. That is one development which I suppose, and I think is a little controversial too, because the other aspect, Section 19 awards or gives rather the high courts also the same power. But that is more of a academic question, and the issues can be raised when you're or maybe answered or studied by you when you're doing your doctoral researches or something, or maybe when you're involved in the practice of it, and you can really come out with what drawbacks Section 17 and Section 19 being very materia which each other have. The other aspect also, and it's very crucial and important, is that objections today to an award are very time bound. You take an objection within 3 months, an extendable period of 30 more days, and this is provided under Section 34. Sometimes it was not always followed in spirit. But now it has come, and I have faced these situations with some companies which were manufacturing vaccine, the prominent one being Bharat Biotech, which is now manufacturing co-vaccine. So during the times of the H1N1 virus, this company was given by the government of India a contract to manufacture vaccine and deliver. There was a dispute, of course, and the award was to be challenged. I was a party to the award. I was appearing for the government of India, the Ministry of Health. And while we were to file a Section 34 application before the Delhi High Court, because of the red tape involved and several bureaucrats involved, the approval for the objection to be filed and the opinions and the file back and forth, up and down, we went beyond the period of 120 days and lost in the High Court because we had filed. Effective filing of our application under Section 34 was delayed by some days. We were over and beyond the period of 120 days. So the courts are so strict that you can't sleep over your rights. Earlier, it was a very lax approach. You're filing an appeal, all right, fine, we'll give you some time. Not anymore. So far, So much to the extent that if you see section 37, I hope everybody knows section 37, the appellate provisions. So if there is a section 34 rejected, then I have the right to file a section 37 appeal. Now the section 37 appeal does not mention any limitation. But recently again, Justice Nariman has held that in the spirit of how much time has been provided, and the spirit of the act is to have the dispute put to rest at the earliest. So, of course, although it is not provided, but let's presume, and we are going to, and the Supreme Court gave orders that the outer limit in filing a section 37 appeal is also going to be 120 days. So within the 3 months and the 20 days extendable period, which also can only be granted to you if you file a limitation, the application for condonation of delay. So an application under Section 5 Limitation Act has to be filed invariably, or the court is not going to grant you any leeway, so to say. So the courts are today ingrained, and the approach is to not interfere so far as possible. To not interfere in the arbitration process itself. And if you read section 34, I hope you have your barracks with you. Of course, I didn't ask for it. You should have conveyed to Mr. Gupta that possibly it may be needed, but let's just read it. So this is how the present section 34 is worded. Now, recourse can only be made on an application in accordance with subsection 2 and 3. This I'm reading from section 34. So if you come down, and the last would be, this is very important. This is what I wanted to draw your attention to, all of you. This would be subclause 2B. There are only two grounds mentioned there. One is public policy of India, if the award is against the public policy of India or contravention, which is the second one. The first is that the dispute is not capable of being adjudicated by or decided by arbitration. So firstly, the subject matter is such that, arbitration by itself would not have been the proper method. And the second is that the award is against the public policy. Now, the public policy head was, if you remember, associate builders, the associate builders case, wherein the public policy head was in para 42 and 43, it was elaborated upon. This has now been reduced because the public policy was a very broad head. You see, public policy, I would say, in the terms or the words used by George Washington, he says public policy is an unruly horse. It'll take you up the mountains and then it'll take you in the depth of the valleys. Public policy is such that you cannot have your government policies because the public wants it, because public may want Salman Khan to be the president. You don't want that. I'm sure you don't want that, right? All right, anyway, so the public policy was a very unruly concept as we understand it in the legal parlance. There is no set contours to a public policy. So the courts were setting aside awards on the basis of public policy, and well, the understanding of public policy would invariably be, it would be in tune with what the judge has in its mind, the predilections of the judge, the behavioral pattern of the judge itself, how the judge has conditioned himself over a period of time. So if he is somebody who's come from the commercial aspects of things, he would not interfere. But if he is somebody who's come from the lower judiciaries and who has been ingrained to follow procedure, to follow CPC, Evidence Act to the core, sometimes there are judges who follow it to the hilt. Even so, if your affidavit is not verified properly, they'll just throw out your applications. So if you have such judges, and it's not bad to have such judges, we really need all sorts of judges that we can have. So the public policy, the principle was becoming a principal ground, and it was a very subjective, it does not have any objective contours to it. If according to me, this is something which is against morality, and I might be approved, so to say, So if I am such, and then according to me, wearing jeans is against public policy, as on certain occasion have been stated by certain panchayats and whatnot. Carrying mobile phones would be something that is against public policy or morality. So this being a subjective term, it permits you of a wide interpretation depending upon what sort of a predilection the judge has. And that is why in certain judgments, primarily which the last one was associate builders versus DDA. And this was where the Supreme Court limited the concept of public policy under certain heads. This was further uh, explained by section 34 again. And the words used, I'll specify. The explanation first is how public policy, or what heads of public policy would an award be stayed on? I mean, what could be the possible grounds? And it has said, I mean, the section limits itself to three. The first is if the award was induced by fraud or corruption or was in violation of section 75 or 81. The fundamental policy of Indian law. It is a better phrase than what was earlier used in the judgments. It says the fundamental public policy of India. Now it says fundamental policy of the Indian law. So it is limited in its interpretation to what you can gather from the law. Law as the legal word, the enactments or the constitution. So if I am violating Article 14 straightforward, or I am in violation of natural justice, this would be something which is a fundamental public policy violation. The third is, it is in conflict with the basic notions of morality or justice. Now this is a little problematic. I still have some issues with it. I'm not really convinced that it should be there. What is fundamental notion of justice? And what is a fundamental notion of morality? Fundamental notion of morality and justice. So somebody, I mean, given an interpretation, the conjunction here, and would say morality and justice together. Some would say, no, you know what, this and is to be used as or, and it could either be morality or justice. So it opens up to a lot of controversies, possibly interpretation, although we haven't had many as of now. And fundamental notions of justice, I would say the very fundamental natural principles of justice, it should limit itself to, which is I was not given a fair hearing, the judge was biased, the bias was visible, and the other legal maxims such as which would give out the feeling that justice was not done, because as you understand, justice should not only be done, it should be seen to be done. So if there was something which gives out a fundamental bias, and it is the understanding of one party, he's able to show to the judge or in his objections that this was the case, then well, yes. But if we are going to go beyond that and justice means everything and anything to everybody, so it's a little problematic. But well, we are growing, so hopefully we'll further with this, and someday better sense will prevail and we'll have it worded better. I think I am going beyond time. We've agreed to an hour, and it's about 5-6 minutes beyond that. I really hate to overstay my welcome. So any questions, if anyone has, I would be glad to.
So there are a few questions in the chat box.
You've got, who's got? Sorry, I can't make out with so many screens on. Who am I talking to? Who's referring?
Sir, I'm Aditi. There are a few questions in the chat box.
Oh, there are a few questions in the chat box. All right, give me a moment. Okay, let's see. It says अंग्रेजी में ज़्यादा interest नहीं आता कुछ समझने में. I don't think I'll be referring to this one. Disadvantages of ADR.
Suggestions are more than questions.
I suppose. Well, can we appeal against an ADR judgment or not? Yes, of course, you can appeal against an ADR judgment. It's called objections under 34, which I suppose everybody knows already. Are only commercial suits entertained again under ADR? Well, I would say anything which you can come to an understanding with an agreement can be challenged by an ADR. So compounding of offenses is something which would not be covered by an ADR process. But apart from that, all commercial nature disputes, property disputes, even to the extent that if I have an interest in the property and I want to settle it against the tenets of inheritance laws, such as the Hindu law or the Mohammedan law, I am free to do it because, well, my right I can waive. As such, any right to transfer of property or any right in a title or even in intellectual property, if I have any. So anything which remotely, gives me a connotation of waiving, I suppose can be. But again, then it would depend upon what legislation we are specifically talking about, because, well, I cannot have a divorce settled by ADR, specifically by ADR. I'll have to eventually go to the court and tell them, well, this is how on mutual terms we're deciding to part, and that will become a decree of the court. I cannot just say, I am going to refer my divorce petition to a private or a divorce dispute to a private forum, and they'll decide, and thereafter we are done with it. Well, because that does not have any sanctity as such. Of course, the terms of the divorce can be settled, and that agreement has to be put to the court, and then the court would, turn that into a decree, and that is only when it becomes binding. So not everything can be put to ADR. You cannot. Even commercial disputes, as I told you, in my own experience, commercial disputes which are secured by fraud, or if the contract is secured by fraud, or it has criminal elements to it, cannot be put to arbitration as such. So that's one. Are there any more questions, pertinent ones? Okay. I'll do one thing. I'll just read them and I'll see which ones to answer. Okay, well, I'm open to any verbal questions if anyone has, because I don't think the chat really has many questions. Sure.
Good afternoon, sir. First of all, thank you so much for such an interesting discussion on ADR. Secondly, sir, my question is, if a party has already filed a civil case on a particular matter, and then thereafter a party again files an arbitration matter on the same case but does not disclose it.
No, sorry, your question would be, if there is a pending dispute in a court.
Right. So if there's already a pending dispute, I suppose that it's extremely pertinent for the party to mention it when they are filing for arbitration. And if they have not disclosed it, what can the party do in such a scenario?
Well, Akanksha, what happens is there's a technicality there.
Right.
If I have a pending dispute before a civil court, and thereafter I initiate arbitration, then obviously the other party has to be brought to a notice, and I need to agree on the arbitrator. So if I am already a party there, I'm already a party to the civil suit. Let's go tuckle. So obviously the notice would go to the court. And in most cases, what happens is, if it is a commercial dispute or a dispute which is suitable for arbitration, the court is obligated under the CPC to first refer you to arbitration. So the first thing has to be done. And in case you are inclined, and this gives an inclination that you're inclined for an arbitral proceeding, the court will stay its own proceeding, send you to arbitration. If it is possible for you to have your dispute redressed there, you can come back to the court and tell them, yes, this is how it has come to a fruition. and you can wind up your proceedings. So this is an obligation of the court now under the CPC to have you referred to arbitration. Whatever dispute you bring to the court, if the court is of the opinion, the first thing the court has to do is this. And if during this pendency and you go and file an arbitration, you can't just file an arbitration. What you do is you invoke arbitration. So if you give notice to the other party and it is brought to the notice of the court, then obviously it is the same case where you're interested in having your dispute settled through arbitration. So therefore, what happens is that it will keep the proceedings pending in case they've reached a particular stage, so to say. And even after framing of issues, they can refer you to arbitration. Right.
Thank
So
you, sir.
depending on the stage.
Thank you, sir. Thank you.
Right. So if there are no more questions, then I suppose Dr. Gupta, I thank everybody for holding such a very peaceful it was. I mean, there was no interference. What happens is that with so many students, sometimes it just goes anywhere and everywhere. But anyway, it was nice being here, and I hope to be associated with you in the near future. And we'll have more of these in the coming times, right? So I thank the faculty and the students and Mr. Gupta and Mr. Juniwal for such a great opportunity. Thank you so much.
Thank you, sir. Thank you. We are very grateful to respected Smith, sir, for his words for encouragement, his able guidance, and always encouraged us. I thank you, my friends and my students and other faculty members to cooperation for making this event. Thank you, sir. Thank you.
On a parting note, in case any student has any issue, any query, or you really want to approach me about certain other things, you can have my contact email from Dr. C.P. Gupta or anyone in the faculty. And you can always shoot me a mail. I'll be more than glad to help you out. Okay? Thanks, people. Thank you for patience.
Thank you.